So, you are welcome, dear ladies and gentlemen. As always, Brighton Mtejechi is my name, as you can understand. This is the YouTube channel where we always dive into uh, the purposes, the essences of law. Basically, we always talk about the law topics in LLB. This is to help you, the student, and the law school, and the entire country, the students, so that we can learn together topics in law school. As you can see, it is a little bit late. It is midnight. You can witness. So today the topic of emphasis, but before that, I urge you to subscribe and share, because once you subscribe, then you're helping yourself and other friends, that once any other topic is released, then you will be able to receive the topic in a reasonable time. Today the topic of emphasis is evidence law 1. So when we talk about evidence law 1, is in my first video I talked about the introduction to evidence. What is evidence? uh, uh, Types of evidence. So we talked about that. So now we are going to look at section 5 to section 14, or you can easily call it res gestae. So let's start. When you look at section 5, it talks about facts that form part of the same transactions. So when you look deeper into this, you have to understand that when certain facts combines together and you find they form a link, what you can call a transaction. That, let's say it's murder, someone killed the deceased, then you find that before that, that person already had a gun to shoot, and already he had the intention, the motive, that he could even go ahead and threat the deceased. Then after, the issue now is uh, killing or murder. So when we combine all those facts, all those uh, things, it forms the transaction, the process, what we call facts that can form part of the same transaction. So those parts which are similar, that at the end of it all, they are causing something to happen, then that's why, or that is how we can try to explain to you easily, you can understand section 5. So by the landmark case Allah versus Kuji, whereby the accused stabbed the brother of the deceased, and before that he uttered out threats to the deceased. Then after, he was found standing up with the deceased body with a dagger, you can call it iron made like, that he used to stab. So when you combine threats, you combine with the action, standing up the deceased and the dead body being there, then it confirmed that res gestae section 5 can now be explained in that way. When we look at section 6, because I told you we have to drive from section 5, section 14. So section 6, facts which are occasion, cause, or effect. So in this way, we are saying that when you find the facts which are the real, which can introduce, which are the cause of the action that has happened. In McKinney versus R, the appellant was convicted of manslaughter of a boy, whom they are saying that So whom we say that this boy uh, died due to another things. For him, he said that it was epileptic attack. Epileptic attack, if I can explain it, is when you find those guys, they call people who who basically they get taken take it like a shock. uh, Take an example, like in rainy times you find uh, people getting shock due to coldness, but uh, being that he severely beat the boy, several beatings caused the death of the boy. So in this case, the court held that the boy died due to several beatings. So it shows the cause, the effect, the cause and the effect, what led something to happen. So that is section 6. So when we dive into section 7, section 7, which talks about that facts may be relevant, which shows or constitutes a motive or preparedness. That the preparedness for any fact in issue or relevant fact. So in any conduct of the party that portrays the preparedness, motive, and preparedness. Uh, so in this case of R versus Robo versus R, when you read it very well, it will explain on how uh, the preparedness. Preparedness means that someone prepared the way on how he will act something. So it means that person already showed the intent and motive. So the motive uh, goes with preparedness, because when you prepare, then you already have the motive, the intent, uh, the the motive and the intent. So let's dive into section 8, which talks about the introductory facts or explanatory fact. So in this way, uh, we talk about on how facts can be introduced in a certain proceeding. If I can give you an example, is on how you find that the facts are saying, I killed, but by that time I wasn't at the crime scene. I was somewhere. So the facts are introducing a new thing. So in this way, this commonly works in rebuttal cases, where you find that you're saying I was here, but at this time of acting. But for me, I'm explaining that I wasn't there. I was somewhere. So it's up to me to prove. If I'm saying that the moment you're saying that I was in, let's say, use Kampala, I was in Mbalala. So it's me to prove where I was. If I was in Mbarara, what shows that I was in Mbarara? So something of that kind. You understand? So section 8 goes ahead and explains the following elements. One, it explains the facts that explains on introduce of a fact in issue. When you look at section 2, the Introduction of Evidence Act, it talks about a fact and issue. So read it, you will find the relevancy of it. B talks about facts that support or rebut an inference. As I've already said, that facts that can support the already fact or rebut the fact at hand. We have facts which establish identity, where identity is in issue. An example, if you're saying that the killer was tall, so in this way, you have to explain the accused. Take an example, explaining using the height, the sex of the person, the color of the wear, or any other form that can identify someone that he really did something. So, in this way, the facts must show the relationship between the action and the person doing the action and the structure or the moments or the process or called the transaction on how this happened. If you're saying uh, uh, an example that the man who did this is big in size, somehow tall, black in color, then at the time of identifying, then the person should not be rebutting the same facts. So read the case of Francis Kayemba versus Uganda. You will get to understand more. Uh, let's dive in section 9, which talks about conspiracy or common intent or common design. Now, what do I mean? That conspiracy same applies or subject to section 20, if I'm not mistaken, of the Penal Code Act revised. So it talks about conspiracy. The conspiracy where you find different parties conspire or engage in doing something. So in this way, you have to prove the common intent. There must be the common intent that really what you have done or what we have done, we had a common intent. We knew about it. You may find, for you are saying that we did this together. But again, for me, I didn't knew about it. An example, if I can ride the border and I take someone somewhere, or someone tells me to take him somewhere, we reach there, his intent is to grab like a phone from someone. The moment that person did that and he said that we are together, then it's up to me to complain and rebut on how we never had a common intent. Because for me, I never knew about it. I'm a boda guy. I ride my bike. So when I ride my bike and I take someone in some place, and someone do something, then there's no way we will come out and say that we were together, however much we were together, but you will not say we did it together, because for me, my role was to take someone somewhere. So it is not in order for you to say we did it together because we are together. The common intent must be proved. So read the case of Barikade versus Uganda. So where the court it held that in order to prove common intent, it is, I mean, they are trying to mean that in this way, the common intent should be the key element to prove. So you have to understand it in that way. Section 10. Now, section 10, it is a little bit somehow confusing, but it is okay. Now, when you look at section 10, facts not relevant to be relevant or otherwise becomes relevant. Facts irrelevant otherwise becomes relevant. So what do I try to mean? I'm trying to mean that when you find facts which are relevant, they can be irrelevant, or at the same time facts which are irrelevant can turn into relevant. How can that happen? Now, when you look at cases, rebuttal cases, the reason why I'm using rebuttal cases is because they can they can explain it very well. Now, an example is when you say that at the time of killing, I wasn't there. It is not me who killed. I was in Mbalala, but for you are saying the killing happened in Kampala. So, when the facts are relying on the circumstances that someone who was killed in Kampala, who was killed by so and so, those are the facts. But me, when I rebut it and say no, I was in Mbarara, but you're saying I killed. Uh, at this moment, I was actually traveling in the bus coming from Mbarara, and this is the ticket of the bus, which is showing the time and the bus, the date. So, meaning that facts which you've been relying on as relevant, now they are becoming irrelevant, or vice versa. So, you understand it in that way. So, have the case of Uganda versus this man Sabuni. So, the accused was convicted with robbery. So, by that time, the claimant said that by that time he was not in the country. So understand it. Now, Section 11 of Evidence Act, where they are saying in suit for damages, facts standing to enable court to determine amount and relevance. What do I'm trying to portray now here? I'm trying to mean that uh, where the court will stand in, look into facts and determine the amount or the weight of the damages that you may be suggested to pay. Take an example. In cases of uh, false imprisonment, uh, in cases of, yeah, let me say that I entered into your house, you locked me in there. By the time you locked me in there, I was going to work. You released me after 10 hours. Then, as I saw you saying that uh, I lost my businesses because of the time is spoiled for me. So the court will rely on how, what if you were not detained and you were let free to go? Surely, were you going to earn those amounts you're saying that you lost? So the court will stand in, will investigate and see this the sum, the amount that they can be awarded as damages. So that is the section, what the section is trying to mean. Section 12, as we are winding up. Section 12, facts relevant when right or custom is a question. Now, when you remember the case of Bruno Chiuwa versus Juliet Namazi, uh, which you can understand it very well that the custom, if the custom is the question, now we are going to see the relevancy of the custom. If the custom is well recognized and the custom is well recognized, then which means it will taken to be relevant. So I can explain it in that way. Read the case of Brunocho versus Juliet Namazi, it will give more explanation. And just remember that we are not explaining each and everything uh, in this, so you have to go ahead and make more research. We just give you a light on how you can interpret, you can get across the topics. So section 13, which shows facts showing existence of the state of mind of body or bodily feelings. So in this way, we have to understand by the time something happened, the bodily feeling, how was the bodily feeling? In times, take an example, like Mm, I may use like another example, the time when you tried to box me and oh, you tried to slap me, then you're suggesting that you had no intention to slap me. You didn't intend to slap me, that it was a mistake. Maybe you was going to slap something, you end up slapping me. So we shall see the feeling, the bodily feeling. How come that you're facing me, but you're saying that you are going to slap someone else? So now we prove the following: uh, the sanity, uh, which means that the state of mind. What was the state of mind? If that person was a reasonable person or normal, so we have to prove that. The knowledge, the knowledge, you had the knowledge to do something. It wasn't a mistake. If it is a mistake, then we investigate on that. The intention, you intend, really you intend. It was a mistake, you didn't intend, or you intended to do something. So in such way, you have to understand that, or you have to get it in that way.